case of Boland v. Bonta was a challenge to California's handgun roster, okay? The judge in the case essentially put a preliminary injunction in place saying that the drop test requirement is probably constitutionally valid. However, microstamping technology, loaded chamber indicators, and magazine disconnects all violated the Constitution. My name is Stephen Lieberman. I'm one of the attorneys with the law firm of Lieberman and Taormina, and I'm also one of the owners of the Artemis Defense Institute in Lake Forest, California. Today, I want to talk to you about a development in the case of Boland v. Bonta that I talked to you about just the other day. Now, before we begin, USCCA, which is sponsoring this video, is doing a really cool giveaway. It's for a limited time only. I will tell you that the thing that they're giving away will fit in your holster. So I encourage you to click on the description. All right, so what happened in Boland v. Bonta? Now, some of you may remember that a few days ago, I did a video similar to this one. Many of you commented about my powder horn and possibles bag in the back. Thank you for that. Now, you might remember from that previous video that the case of Boland v. Bonta was a challenge to California's handgun roster, okay? Those guns that are certified, well, those handguns that are certified for sale in the state of California. And up until this case, there were 4 requirements for a gun to be certified for sale and therefore placed on the roster. The gun had to survive a drop test. It had to have a loaded chamber indicator, a magazine disconnect, and microstamping technology. The judge in the case, Judge Cormack down in Orange County, essentially put a preliminary injunction in place saying that the drop test requirement is probably constitutionally valid. You can continue to have a drop test. However, microstamping technology, loaded chamber indicators, and magazine disconnects all violated the Constitution. They were a direct infringement on California citizens' right to bear arms. So, not unsurprisingly, the state of California has appealed this preliminary injunction to the Ninth Circuit Court of Appeals. Now, it's unclear as of this video whether or not the Ninth Circuit is going to grant a stay on this injunction. We'll have to see on that one over the next couple of days. But what's fascinating is not the fact that the state of California has appealed the injunction. What's fascinating is their reasoning behind appealing this injunction. So I've been reading over their moving papers, and, not surprisingly, they said that the judge did the constitutional analysis completely incorrectly and that there's no irreparable harm that will be suffered by the plaintiffs, that they still can get guns. But their chief argument is not that there is a constitutional issue involved here. Their chief argument is if the preliminary injunction is allowed to stand, then state workers are going to have to do a lot of work. I kid you not. I mean, that is literally the gravamen of their argument here, is that they will be compelled to actually work. They admit the fact that no new gun has gone on the California roster since 2014. And during that time, a lot of new guns have entered the marketplace throughout the rest of the United States. Bonta, the Attorney General, his fear is that all of these manufacturers are going to flood the Department of Justice with all these guns that people in California have been dying to get. And as a result of that, they're going to have to do a lot of processing work to have them go to a certified lab and do a drop test and all these other things and then physically be added to the roster. And that somehow this will create an undue burden on the state workers. Forget the constitutional violations that are accruing on the part of the plaintiffs, and for that matter, all the people in California. They are concerned about having to work overtime. This is literally the argument that these people are making. Now, what's also interesting is that they essentially punt when it comes to the microstamping technology. They're not asking for the stay to be lifted on the microstamping. Now, this might suggest that they sort of acknowledge the fact that microstamping is simply not going to be seen as being constitutionally valid under any rubric. We'll have to see how that ultimately plays out. But what they're asking the Ninth Circuit for right now, just to kind of wrap this up, is to put a stay on the judge's decision preventing or allowing guns to be tested by the Department of Justice in one of their certified labs, and only having the requirement that it survive a drop test. They want the loaded chamber indicator and the magazine disconnect to also be a required component. So we'll have to see how this ultimately plays itself out. We should probably be getting some notification from the Ninth Circuit in the next couple of days. But until then, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.